Boundless Immigration News, Weekend Review, April 29, 2022. Supreme Court worries that Remain in Mexico interferes with foreign policy. The U.S. Supreme Court, on Tuesday, heard arguments over whether the Biden administration can end a Trump-era border policy that forced asylum seekers to wait in dangerous shanty towns in Mexico for their U.S. immigration court hearings. The Biden administration has tried to end the Migrant Protection Protocols, or MPP, which is usually referred to as Remain in Mexico. The policy began in January 2019 and was suspended and then formally ended by President Biden in January 2021. However, the states of Texas and Missouri sued the administration to force the program back into effect. The case has made its way to the Supreme Court, where the justices focused on what Congress intended when it passed the law at the root of the case, and whether the government has discretion to decide what to do with asylum seekers it cannot jail. One of the most important considerations for the justices and for the Biden administration, however, is the way MPP interferes with the president's power to conduct foreign affairs. Justices pushed back against the idea that a state could basically tell the president how to implement its foreign and immigration policy. U.S. pledges ongoing support for Ukraine, plan to reopen embassy. The Biden administration made a series of announcements this week pledging ongoing American support of Ukraine as the war with Russia enters its third month. On Monday, a State Department official said the U.S. planned to reopen its embassy in Kyiv after closing diplomatic operations days before Russia invaded the country on February 24th. American diplomats will begin making trips across the border from Poland to Ukraine this week and will resume embassy operations in Kyiv within weeks, a State Department official told reporters in Poland. The United States shut its embassy in Kyiv on February 14th, just 10 days before Russia began its military invasion. President Biden also announced Bridget Brink as his pick for ambassador to Ukraine. She'll be the first American ambassador to Ukraine since 2019. The president launched another initiative this week that will allow up to 100,000 Ukrainian refugees to temporarily stay in the United States under a system known as humanitarian parole. The program, called Uniting for Ukraine, allows Americans, including green card holders, to sponsor Ukraine migrants if they can prove they can financially support them. If you're interested in applying, visit the government page for the program. Federal judge holds Biden to May 23rd end of Title 42. A federal judge in Louisiana blocked the Biden administration from whittling down an early Trump-era border policy that automatically turns people seeking asylum away at the U.S.-Mexico border without a hearing. The policy, known informally as Title 42, has resulted in nearly 1.5 million people being turned back from the U.S.-Mexico border without a hearing in the past 2 years, including at least 200,000 parents and children and nearly 16,000 unaccompanied minor children. The administration announced at the end of March that it would end the use of Title 42 by May 23rd, which would fulfill one of Mr. Biden's campaign promises. The announcement was met with lawsuits by more than 20 states, including criticism from within the Democratic Party. The Department of Homeland Security, or DHS, was beginning to increase their use of their regular immigration processing at the southwest border to prepare for the end of Title 42 on May 23rd. The phasing out of Title 42 processing in favor of regular immigration processing caused the states of Texas, Missouri, and Arizona to ask a federal judge in Louisiana to stop DHS from moving away from Title 42 before May 23rd, which was granted on April 27th. Biden administration continues DACA fight. The Biden administration is using a recent federal court appeals decision that put the brakes on states' ability to stop national immigration policies in its fight to lift a judge's nationwide block on new applications to the Deferred Action for Childhood Arrivals, or DACA program, which grants work authorization and deportation protection to undocumented people who were brought to the United States as children. Lawyers for the Biden administration filed a notice with the Fifth Circuit last week, pointing out that a recent but unrelated appeals court ruling in the Sixth Circuit that found a group of states did not have the grounds to sue or block the Biden administration's immigration enforcement priorities. The Sixth Circuit ruled last week that minor costs to a state because of a federal government program are not enough to get the state standing to block the program. DOJ lawyers hope to draw a line between that ruling and the similar facts in the DACA case, which was also brought by a group of states claiming the program caused them additional costs and burdens. Foreign artists and athletes struggle to get visas. Foreign athletes, artists, and performers applying for a U.S. visa are facing processing delays, increased scrutiny, and misapplied or confusing rules that began during the COVID-19 pandemic even though travel restrictions are decreasing and athletic and artistic events are beginning to ramp back up. Foreign athletes, artists, and entertainers can seek P visas to enter the United States to participate in a competition or performance, while O visas may be approved for anyone who is recognized for extraordinary ability in their field. As the COVID-19 pandemic continued, the previous administration added many new restrictions, including for O and P visas. Difficult and burdensome requests for additional evidence, RFEs, by USCIS also increased dramatically, especially for foreign athletes. O and P visa applicants are also facing extraordinary backlogs at U.S. Citizenship and Immigration Services, USCIS, which processes the initial I-129 petition, as well as the Department of State, DOS, consulates that issue the actual visa. Many consulates are still closed due to the pandemic or functioning with minimal staff. As the agency struggles to process the applications in a timely manner, O and P visa applicants can miss out on work, competition, or performance opportunities, while depriving people in the U.S. the benefits of those extraordinary people's talents. Those are this week's top immigration news stories. If you found this video helpful, please be sure to give it a thumbs up and subscribe to Boundless for the latest in immigration news. Thanks for watching.